Text messages can feel like the clearest proof in a family law dispute because they preserve words and timestamps. But a screenshot pile creates new questions. Who sent it? What conversation came before it? Whether the image is complete? What issue it proves? And whether the court's filing or evidence rules require something else. This episode is about organizing text messages for review and asking the right local process questions. It is educational information, not legal advice, and it does not predict admissibility in any court. Before exporting anything, write the one issue the message relates to. Is it an exchange time, a notice, a payment, a school decision, a safety communication, or something else? Then write what you want the message to show in one neutral sentence. If you cannot write that sentence, the message may be emotionally important but not yet organized for this hearing. Separate messages that relate to the issue from messages that simply make you angry. The court may have limited time, and your preparation should help the judge find the relevant point. When a message matters, preserve enough surrounding conversation to explain it. Record the date, time, sender, recipient, and the device or account where it appears. Avoid cropping away the identifying information unless you are following a privacy redaction instruction. Keep an original export or unedited copy in a safe location, then make a working copy for highlighting and indexing. If the message is in an app with changing content, document the method you use to preserve it. Your goal is not to create the most dramatic screenshot. Your goal is to maintain a traceable record. Create an index with 5 columns: exhibit label, date range, participants, issue, and what the record supports. Keep each entry short. For example, one line may say, Exhibit B, March 3rd, exchange conversation. Both parents missed pickup, shows the notice and response. Do not write that the exhibit proves every conclusion in the case. Use careful language such as supports, documents, or records. If one event has several messages, group them under one event label instead of creating a confusing exhibit for every screenshot. A message can prove that someone sent words. It may not prove the truth of every statement inside the message, the sender's intent, or what happened outside the conversation. In your notes, make 3 lines: what the message directly shows, what you infer from it, and what independent record could confirm the inference. This discipline helps you avoid overstating the evidence. It also tells you whether you need a calendar entry, receipt, school record, witness, order, photo, or another source to explain the event. Before filing or sharing a document, check the court's instructions about private information and required redactions. Social security numbers, financial account details, medical information, addresses, and information about children may require special handling depending on the court and document. Do not redact so aggressively that the message loses its date, sender, or meaning. When you are uncertain, ask the clerk or a qualified local resource about the current rule. Store the unredacted original securely and do not post family communications publicly. Many courts require documents supporting a family law request to be filed and served before the hearing. A court self-help guide explains that the judge may not consider documents that were not filed and served in the required way and time, even if you bring copies on the hearing date. This is jurisdiction specific. Read the hearing notice, the local rules, and the instructions for the particular motion or request. Keep proof of filing and service. A good exhibit can still be unusable if the submission process was missed. Practice presenting one message without reading the entire phone. Be ready to state what the exhibit is, who created or sent it, the date range, how it relates to the issue, and the specific sentence or event you want the court to notice. Follow the judge's instructions about approaching the bench, offering exhibits, and providing copies. If the other side disputes the message, listen carefully and ask for the court's direction. Do not argue authenticity, hearsay, or other legal objections, as if a generic internet rule settles the question in your jurisdiction. Your final packet should contain a current order or notice, an exhibit index, the complete relevant message threads, clean working copies, proof of filing and service if required, and a one-sentence explanation for each important exhibit. Then put the phone away and prepare your timeline. Text messages are one category of record, not the entire case. The Child Custody Hearing Roadmap at practicalcourtprep.com can help you organize evidence by issue and date while you verify the rules that apply to your court. Download the Child Custody Hearing Roadmap at practicalcourtprep.com. Educational information, not legal advice. Verify current local requirements.